Honorable Governor of Andhra Pradesh and former Judge Supreme Court of India, Honorable Sri A.S. Bopanna and Justice Arvind Kumar, Judges Supreme Court of India, Honorable Chief Justice of High Court of Karnataka, Prasanna B. Varale, Chief of the Karnataka State Legal Services Authority, Honorable Justice Narendra, Judge, High Court of Karnataka and Chairman, Karnataka State Legal Services Authority, Honorable Judges of the High Court of Karnataka, Dr. M.R. Chairman, Gokula Education Foundation, Sri M.R. Sitaram, Vice Chairman, Sri M.R. the Director, Ramaiah College of Law, and the entire family of M.S. Ramaiah Institutions, Sri Ram Prasad, former IAS Chief Executive, Sri Uma Mahesh Satyanarayan, Principal, faculty, staff, and students of Ramaiah College of Law, learned senior advocates and learned advocates, learned Registrar General and Registrars of the High Court, distinguished invitees, students of the law colleges who are participating in the Qanun of Santé, members of the press and media, and ladies and gentlemen. I am very delighted to be addressing this august gathering on the occasion of the Silver Jubilee of Ramaiah College of Law, on account of which this meaningful function, Access to Justice Conclave, has been organized in collaboration with Karnataka State Legal Services Authority. I thank Gokula Education Foundation and Ramaiah College of Law and Karnataka State Legal Services Authority for inviting me to my hometown. It is a significant coincidence that this year marks the Silver Jubilee of the Ramaiah College of Law and also is a birth anniversary of Dr. M.S. Ramaiah, a doyen in the field of education, a visionary, a philanthropist, and educationalist, who established around 60 years ago the Gokula Education Foundation and has pioneered the galaxy of institutions thereafter. M.S. Ramaiah Group of Institutions is a sought after, not only in the field of medicine and engineering, but also dental sciences, management, and now law. Owing to the dedication in the field of law, the institutions have got the recognition of a private university. The services rendered by the medical and dental hospitals through their respective faculties and students have earned a unique place in this field. On this occasion, I must remember that my father was associated with this group of institutions as being part and chairman of the ethics committee way back in the 90s, and now my husband is associated with the M.S. Ramaiah University of Applied Sciences. The Ramaiah College of Law is also a center of excellence in the area of legal studies. The initiatives such as Access to Justice Conclave enables the students to have an exposure to the profession of law even when they are still in the college. I congratulate the Ramaiah College of Law and Karnataka State Legal Services Authority for organizing this conclave. Access to justice, as we all know, is a people's principle, which is fundamental as a human right. It all depends upon the citizens' knowledge of rights and the access to tools to enforce those rights effectively and affordably. Making access to justice a reality is, in my opinion, one of the most laudable objects of the Constitution. We all know that the preamble says, and it gives citizens social, economic, and political justice. In order to make this a reality, we have Article 39A, which states that the operation of the legal system promotes justice on the basis of equal opportunity. Equal opportunity must include the provision of free legal aid by the state to ensure that opportunities for securing justice are not denied to any citizen owing to economic or other disabilities. Access to courts, in my view, is a component of access to justice. This includes enabling litigants to overcome barriers to getting into court, ensuring that appropriate treatment is meted out within the court system, which would in turn ensure that the litigants obtain just outcomes from the court system. In this, there are various levels, and the first is to give legal aid to the disadvantaged society sections of the society. I must emphasize here that giving legal aid to the poor is not the same thing as poor legal aid. If legal aid must be given to the poor, it must be quality legal aid. The Legal Services Authority across the country must realize as to why many people are not availing legal aid services. In my view, there are two reasons. One, because the people are not aware of the legal and constitutional rights for which the legal awareness camps are conducted with the assistance of the colleges and the students and paralegal volunteers. The second is that they do not have confidence in the quality of legal aid offered. This reason is quite dangerous to the system of legal aid itself. I will urge the legal services authorities to recruit onto their panels lawyers who are qualified and who are willing to give their quality service. I exhort all lawyers who are gathered here and to appeal to all lawyers, both young and experienced, to come forward to offer their pro bono services. I am sure that there are nearly 200 senior advocates practicing in Karnataka. Even if they do 2 pro bono legal aid cases, it would make a big dent and significance to the system. I appeal to the senior advocates who are gathered here and through them to everybody to offer themselves to do at least 2 legal aid briefs in a year. This would inspire younger advocates to empanel themselves and render pro bono services. I must recall to this august audience that way back in 1948, my father started the Legal Aid Society, and it was through that legal aid, one of the most important cases, which is commonly known as the Drayton murder case or the Joker case, he argued as a pro bono way back in the 1950s, and as a result of that argument made in the High Court, an innocent man was saved from the gallows. You know, those days, those who are aware of the Drayton murder case will know that that was a pro bono litigation which my father took up. I must say that I have been on the panel of the High Court Legal Services Committee and the Karnataka Legal Services Authority for about 10 years, and it has given me immense satisfaction to be working for the legal aid on a pro bono basis. I can give you only one example, and that is with regard to the Sheila Parsa case, where the public interest litigation was taken up by the Karnataka State Legal Services Authority, and that was with regard to improvement of the conditions of mental health in the state of Karnataka, and one result of that was the Dharwad Mental Health Institute was improved. The second element is with regard to Legal Services Authority taking up public interest litigation wherever it is necessary and utilizing the services of the panel advocates for ensuring that the welfare legislations are implemented. That apart, I must say, as far as ordinary civil litigation, writ petitions, etc. are concerned, the Legal Services Authority and the various authorities at the district and taluk levels must assist the persons who are in need of legal aid to have access to the courts. Then only the discourse of access to justice would become more meaningful. Of course, the yeoman service rendered through the system of Lok Adalat must be complemented, but that is in the context of reduction of tendency of cases, not so much on access to justice. In my view, if access to justice has to be more meaningful, it is the district judiciary which must really take into account what is the real meaning of access to justice. High standards must be maintained by the advocates who are empaneled in the district judiciary as advocates of the Legal Services Authority, and who must have a mission to accomplish and not merely to have their name put on the panel. I must also inform that the Karnataka State Legal Services Authority as well as the district and taluka authorities must assess the performance of the advocates who are empaneled. What is the quality of service that they are rendering? Whether they are demanding fees from the persons who are referred to them for legal aid, whether they are attending to the cases or they are ignoring the legal aid cases for their other private briefs. There must be a mechanism to assess, and in this way, response of the litigants to with regard to the services rendered by the advocates on the legal aid must be there, so that the constant assessment of advocates by the Legal Services Authority would ensure that the really good ones are retained on the panel and the other ones are removed from the panel. I must also say from experience that one of the problems with regard to legal aid cases is the delay in the filing of cases. This is because the authorities first try to seek an opinion from the advocate whether the case is fit to be filed. But I must tell you that there are so many cases, such as where there are jail appeals, cases against scheduled caste and scheduled tribe violations, cases with regard to assault on women. Where is the question of taking an opinion whether it is a fit case to be granted legal aid? They are off. As of right, they are entitled to legal aid. In such cases, the quicker process must be adopted, and for this, we require dynamic judicial officers to be appointed as member secretaries of the Legal Services Authority. Usually, what we find that some judicial officers who are not good on the judicial side are made to do work on as member secretaries of the legal services committees, because there is no deciding of cases there. That approach, in my view, is not at all correct. You must pick up the best of the judges who have a passion for rendering legal aid through their member secretary post, and they must be trained in the judicial academy as to what their post entails. Then only we will have this access to justice more meaningful. I must say one more aspect with regard to access to justice, and that is you must have more gender diversity on the bench, include more women judges on the bench. Then only all other women, which form 50% of the population of India, will have confidence to approach the courts. If you are having only men to decide cases concerning problems of women who may not understand what the woman is undergoing, like today we were able to see the skit, how it is an eye-opener for so many people here today, and I hope this skit is taken to Doordarshan and other media all over the state. I wish that is done, because it will be an eye-opener for the rights. Then only we have more and more women having confidence in the legal system and into the courts. Then the access to justice to women will become more meaningful. Another aspect I would like to stress on this occasion is that on account of the COVID pandemic, what has happened, we have virtual courts. Now, virtual courts are also open courts. In my view, where advocates and litigants appear through the video conferencing facilities, the courts or the judges should not and ought not to snub them because they are appearing through the video conferencing facility. The virtual courts must be just like open courts. The virtual courts also must be open courts. We have our Chief Justice of India, Dr. Justice D.Y. Chandrachud, who is stressing every minute for having digitalization and virtual courts. But we have in some places judges snubbing at lawyers and litigants who are appearing through virtual facility. That should stop immediately. Therefore, I must appeal to all our judicial officers and judges to not snub those who are appearing virtually, either advocates or litigants, and to hear them just like you hear them in the courts. Before concluding, I must emphasize that not the Legal Services Authority, but there are a large number of organizers who are partners to the legal services and for access of justice. Collaboration between such stakeholders, community organizations and other such organizations working closely with the justice system is very, very important and ought to be recognized. The Legal Services Authority must take in their services also in order to ensure that they become more dynamic and inclusive. I must say that conclaves such as this is a great help in molding on the access to justice topic. I am happy to inaugurate the Kanunu Sante, which is a well thought out idea brought out by MS Ramaiah Law College. Clinics for legal aid in law colleges are stepping stones for the future generation of advocates to imbibe the service motto in the legal profession and to make access to justice a reality. I congratulate the organizers of this conclave for their idea and wish all participants in the Kanunu Sante the very best. I once again thank MS Ramaiah Group of Institutions and Karnataka State Legal Services Authority for giving me this opportunity to share a few of my concerns and thoughts on this auspicious occasion. I thank you all for your kind attention.
Honorable Srimati Justice B.V. Nagaratna has cautioned the entire society towards the urgent need of creating awareness camps towards giving and providing legal aid to the citizen fraternity. Let's all once again thank Honorable Srimati Justice B.V. Nagaratna for the keynote address.